You can have Rembrandts in the attic too. Once you find those patents, you can sell them, you can license them, and you can generate revenue from doing that. You need to be able to back up your assertion with litigation. Otherwise, it's very hard for a company to kind of take you seriously. And once word gets out that you're like a paper tiger, no one's going to license you, right?
If there's star references on the front covers of the patents, then you know that your patents that you're filing are broad and they're being used in a defensive purpose, either to get your competitors' patent applications abandoned or the scope of the claims of the competitors narrowed. Which, both of those things are valuable to your company. You file one of these patents, keep it alive by filing continuations, and then as soon as a competitor announces a product or as soon as that product comes out, you can analyze it and you'd have enough support in your patent specification to draft claims.
This is the Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadio. My guests today represent the two essential halves of a winning intellectual property strategy: the visionary in-house leader and the tactical outside counsel. Mark Campagna was most recently the Senior Director of IP Strategy, Licensing, and Acquisitions at Dexcom. He has spent 2 decades transforming patent departments from cost centers into massive value drivers for the world's top companies. Joining him is Ryan Phelan, a partner at Marshall Gerstein. Ryan helps companies structure the complex deals and litigation strategies that turn IP assets into business growth. Together, they are here to share their playbook on unlocking IP value. It is my pleasure to welcome Mark and Ryan to the podcast. Thank you both for being here.
Our pleasure. Good to be here.
Awesome. Mark, Ryan, as you both know, one of the things we like to do on this podcast is that I like to ask every guest to share either a fun fact about themselves or a cringe joke. Which will it be for both of you, and what will it be?
For me, I think it'll be a fun fact.
Go ahead.
All right. So my fun fact, I've lived in 5 states and I've got season tickets to 2 football teams, one on each coast. So San Francisco 49ers, consistent with your background there, and Florida State.
That's fantastic. Thanks, Mark. What happens when, I guess they're 2 different leagues, so they're not going to compete with each other. That's great.
Yeah, I've got a spreadsheet to figure out which weekends I go where. So, and I've got to factor in Purdue too, because my other daughter goes there.
Wonderful. Ryan, what's it going to be for you?
Yeah, I'll follow Mark's lead and I'll stick with geography. I guess I'll cover the South and Midwest since he's got both of the coasts. I'm originally from Louisiana, although I currently live in Chicago, Illinois. Moved here about 20 years ago. If we're going to talk football, whenever the Saints and Bears play, it's always a difficult conversation, between friends and family.
That's great. Awesome. So with that, let's move to the topic of the day, which is this article that we are discussing. So let me start by saying that I understand that both of you have built incredible careers on different sides of the IP world. Mark, for you, it's leading strategy inside giants such as Google, TiVo, Medtronic, and Dexcom. Ryan, you've been a strategic outside counsel, and you have a varied and very technical background with a CS degree and an MBA. You've now collaborated on an article, Unlocking IP Value. And my first question to both of you would be, what was the shared experience or frustration that you both witnessed that made you realize that this playbook was urgently needed?
Sure, I can kick it off if you'd like. So I think, one thing I've seen is that many companies are focused solely on protecting their products with patents, right? Which makes a lot of sense. That's where they're getting most of their money from. But they kind of overlook that their technology can also be used by competitors or even in adjacent industries. And so getting patents that can cover not only your own products, but the other products of other companies and other industries is important. And that's really the first step to being able to understand the potential to monetize your patents, right? And when we wanted to really get people thinking about, how they can use their patents and technology to become a profit center. And so that was kind of the impetus, at least for me, to write this article.
Awesome. Ryan, thoughts on that?
Yeah, just to add to that, I'm an outside counsel looking in, and I work with a lot of in-house counsel, obviously. But what I routinely hear from my in-house colleagues is that they can be looked at cost centers, especially from the C-suite. Usually they're a line item on the income statement or cash flow statement, whatever balance sheet. And it's hard to show value in an intangible line item, such as IP, just because unless you get like some kind of litigation win or there's some kind of licensing deal, it's hard to put a number or draw a value around that. So, I think it's always important to show value to in-house counsel, so they themselves can tell the C-suite, like, this is how we're contributing. We're not only a cost center, we're in fact a very valuable asset of this company. I mean, many people, most C-suites know, people, whether it's a CEO or CFO, they know that they have a product or products, or maybe future products from their R&D. They spend a lot of money on R&D, and showing how that all kinds of lines up, and how that IP department, I think, is very important and is useful to show the C-suite so they're aligned.
Makes sense. Following up on that, Ryan, so what is the most common blind spot that you see in terms of companies that still have that sort of defensive cost center mindset?
Yeah, I think that, at least from my perspective, usually things happen in the marketplace or with competitors that kind of jolt a company into, being believers in IP. For example, patents. Maybe there's a lawsuit. Maybe they get sued, and that kind of shows, the fact that their competitors, or maybe a non-practicing entity or whatever it may be, has patents. They can use patents as a shield in like a sword and shield type strategy. They may also find that a particular piece of R&D that they didn't expect to become valuable becomes valuable. There was no patent filed on that, and then all of a sudden, competitors can just copy that and make similar or different designs. That's value that's lost and that could have otherwise been controlled.
Makes sense. Mark, from your experience in-house, what is the single biggest barrier that you've seen to making the shift within a company from treating IP as a cost center to treating it as a catalyst? And specifically, Ryan mentioned C-suite, right? So how would you start the conversation with the CFO who sees the patent budget as a line item expense and not a strategic investment?
Yeah. So again, I think, like I said, most companies view protecting their profits and the sale of their products as the most important thing, right? And so they're less concerned about how their patents may read on other products and other services. And so really you have to start with IP education and start with the C-suite, right? And explain to them that you need to kind of rethink a little bit of your priorities and understand that you can do both. You can protect your innovations, but you can also profit from your patents. And so when I would talk to a CFO, for instance, I mean, they're a great place to start because they want to see the company increase revenue, increase profit, right? And so they're usually thinking of ways to do that. And so if you come in with an idea like this, they're very receptive to it. Sometimes we've had the CFO come to us and say, hey, like, I went to this conference and Qualcomm was there. They make a ton of money, right? And why can't we do that, right? And so it's a good place to start. And I think first you need to explain that, look, you can have Rembrandts in the attic too, right? And you might be able to, once you find those patents, you can sell them, you can license them, and you can generate revenue from doing that. And then in addition, you can also target your own patent filings to strategically cover both your technology and the technology of other companies and other markets potentially. Stuff a little bit outside of what you would normally patent, right? And you just have to kind of think broader and brainstorm in those areas, right? And then it just takes a little bit of additional thought by your engineers to think of how this technology can be applied to other industries, other competitors. How can we do it different ways? Like, even though we're doing it a certain way, we might have eliminated 3 other ways that it could be done, but it doesn't mean other people might not try that, right? And there could be ways that we didn't try that are in the back of someone's mind that you want to just get all that stuff down and make sure all those options are patented, because in the future, you don't know where things are going to go in 5 or 10 years, right? And one of those pathways that might have seemed like a dead end could be the way that a lot of people do it, or at least one of your competitors does it. And so just getting all that stuff down and capturing all that will give you the kind of the firepower in the future to go down those avenues.
That's great. I love the term that you use there, Rembrandts in the attics. Let's make that real, right, Mark? So can you share a story from your long career across the various organizations I mentioned about a licensing deal that was about more than just a royalty check, a deal that was an actual strategic tool? Maybe it was to enter a new market, maybe it was a partnership, or even to neutralize a.
Yeah, and so one example, without getting into too many specifics, was an acquisition that we did where we bought all the assets of a company, including the IP, and the IP was very important in this transaction. And that led us to be able to expand our products into a new related market. So it was not like just kind of a bolt on something that, made a lot of sense for our company, but it was kind of an adjacent area that we wanted to get into that we really didn't have any IP in. We didn't have any products in this area. And acquiring this company allowed us to not only get into that market, but allow us to partner with others while protecting this sector, right? Because we now had patents that kind of covered this area. And so it just freed us up to work with others and to understand that we're able to protect this area, even though we didn't currently have any products in it. And so I think for me, that was, like you said, that was an entry into a new market and a way to protect it that was primarily based on the IP from that acquisition.
Excellent. Ryan, when you're at the table structuring these deals, your role often is translating that business objective into legal architecture. And so with that in mind, what's a creative, or unconventional licensing structure that you've used to help a client achieve a specific business objective that is above and beyond, obviously, the immediate cash flow or revenues that come from that?
Yeah, absolutely. I think that once you get to that stage where you're speaking with a competitor and you're trying to get them on board as a licensee, a lot of creative things can happen in the agreement document that you write up. And without getting into specifics, there's a lot of different tools you can use. One that Mark mentioned is, you can kind of get the licensee on board with respect to selling a product and it kind of expand your pie, and then close out the market to maybe other would-be competitors if you're going to assert your patent against them, and then only keep in, if you licensed companies. You can also include provisions into your agreement document limiting the number of units that could be sold. Therefore, if you have a competing product that you're selling along with them, you can kind of control market share in that manner. You can get creative with specific ways that they mark a product as well for licensing revenues, and to go back in time for purposes of damages. So there's a lot of benefits other than just collecting that royalty check that you can do by licensing and at the agreement stage.
Makes sense. Ryan, you just mentioned right now asserting your patent, and one way to sometimes do that is to litigate. And there's a really nice phrase in your article, at least one that I like, which is called litigation with purpose. And you write in the article that it's a calculated move and not a reflex. And so, Mark, what is your internal framework for deciding when a lawsuit is a smart business decision versus a resource drain?
Yeah, sure. So I think it depends on your goals, right? I mean, if you want to become a legitimate licensing entity, you generally start by trying to license your patents through negotiation, right? Typical kind of carrot and stick approach. So you'll document the infringement, you'll go and talk with folks, and ultimately, hopefully try to get a license done, right? But if those talks fail and you're not able to get a license done, you need to be able to back up your assertion with litigation, or at least a threat of litigation, right? Otherwise, it's very hard for a company to kind of take you seriously. And once word gets out that you're like a paper tiger, no one's going to license you, right? And so you kind of have to go through that framework, but you really make the decision up front, right? Because if I decide I'm going to do a licensing campaign, I have to know the litigation is a possibility down the road. And I've got to be prepared for that. I've got to set money aside for that. I've got to have the time and resources to go through with that, because the worst thing you can do is kind of start this and then it comes down to, hey, we need to go sue these guys. And the CFO or the CEO is like, no, we can't do that. We don't have the resources, whatever. Like, then you're in a really bad position. So you don't want to kind of back yourself into a corner like that. You've got to think it out strategically ahead of time and make sure everyone understands what you're doing and what it's going to entail in a year or two, potentially.
Makes sense. Ryan, so how would you say this framework has changed in recent years, especially with powerful alternatives like the ITC?
Yeah, I think the framework's the same. I think Mark's exactly right, is that you need to be ready to litigate if the need arises. A lot of times, if you do have a new patent portfolio, chances are you're going to end up asserting that, because the other company is the first thing they're going to do if they receive a licensing letter, is they're going to see if there's any similar litigations out there before. And if there's not, they're the first. They'll be like, well, we don't know the strength of the patents, for example. And so you can expect for a number of things to happen. They'll probably file some type of PTAB petition seeking to invalidate the patents, probably have to go through more rounds of negotiation because there's not like a basis that you can point to for further litigations, and go in with it with the mindset of like, you will have to litigate if your patents are new. because usually during the litigation process, what I find is that the companies come to understand one another through the back and forth. The courts require some level of negotiation or meetings, and the players on both sides gets to know one another. The strength of the patents can be ferreted out via claim construction. I think the statistic is 95% of cases settle before trial, and so there's a lot of information that goes back and forth, and then you can get to that licensing stage that we discussed before and talk about how you can expand the pie by both companies getting something that they wouldn't normally have. Obviously, the licensor will get some kind of royalty fee, maybe some control of the market. The licensee will be brought under the protection of the patents, and the process can repeat to grow the market share of both entities. So I think with first litigations for newer patent portfolios, that's usually the playbook. For a more established patent portfolio where you're kind of a known factor, as Mark mentioned, that the next step is that you're going to get sued, then and that the patents are strong from like a PTAB validity perspective or from an infringement perspective, you're likely to get faster licenses more quickly because you just have more information out there to pull from.
Makes sense. Your article also talks about a proactive strategy of creating blocking patents to choreograph the market. And Ryan, you just mentioned controlling the market. And so I see that as a pretty sophisticated and offensive approach. So Mark, how do you get buy-in from R&D for a patent strategy that is less about protecting one invention and more about strategically boxing in your rivals?
Yeah, so I think it starts with leadership, right? And so you've got to start with, our strategy is to cover our competitors and the white space around our products and their products, in addition to our own products, right? And once leadership is on board with that, they can kind of instill that in their engineers and say, like, this is part of your job is to think outside of the box and to not just think about your own products, right? And then once that kind of baseline is set, then the IP department can kind of come in and do IP education to explain, how we can do this, right? So we can brainstorm with the engineers, we can have them think about alternative ways of doing things, how different technologies can also be applicable to adjacent applications, right? Like one example might be, you've got all the cellular people out there using cellular and Bluetooth for your typical applications for phone and communications. But now with the Internet of Things, it's everywhere, right? It's in medical devices. It's in whatever you can think of. It's in your appliances, right? And so thinking ahead, like thinking of that 10 years ago would have been super useful, right? Because then you can take those patents with a kind of a narrower, scope in telecommunications and apply them to a lot of the different things, right? It's getting your engineers to kind of think about that, gives you the ability to then get these broader patents that can then be eventually monetized, right? Because you've kind of thought outside the box and you've thought about the different ways they can be used and the different, avenues you can go down where they might be applicable.
Got it. Ryan, can you please break down the playbook for how you actually turn that competitor intelligence into a filing that builds that blocking patent, or the picket fence, as you call it?
Yeah, absolutely. Like Mark said, you want to kind of look at and keep tabs on what your competitors are doing, and then put into your patents maybe some additional information that is kind of around the edges of your claims for that would probably claim your exact device. You can know if you're successful later if you see your patents that you're filing ending up in the filings of later competitors. So you can do analysis if there's like backward or forward citations in the patent filings of your competitors, especially if those patents that you're filing end up being cited by examiners. If there's star references on the front covers of the patents, then you know that your patents that you're filing are broad and they're being used in a defensive purpose, either to get your competitors' patent applications abandoned or the scope of the claims of the competitors narrowed. Both of those things are valuable to your company because you're taking out of the market patents that could otherwise be used to preclude, your products and your revenue streams. So I think it's very important to consider, blocking patents and kind of mining around the edges, so to speak, as Mark mentioned, in order to make sure that your patents are blocking your competitors from proceeding with their innovations and therefore blocking your company's progress.
Makes sense. Switching gears a little bit to monetization. So in the article, you both speak about advanced models such as IP-backed financing and spin-offs. To at least the outside viewer, sounds more like Wall Street rather than a law department. So how real are these options for most tech and medical device companies that are out there? Is it something that's reserved for the Fortune 500, or are these strategies more accessible?
Yeah, so I would say, I think the option's real, and you don't have to be a rich company to implement these strategies, right? You just have to have the desire and sort of the internal and external resources to implement it. So it takes a little bit more time up front, especially in the beginning. But once your engineers kind of understand this process and kind of think outside the box and think strategically about how these patents can apply to different fields, it works pretty well after that. Then you're also talking with the finance people. Like a lot of companies, bigger companies can finance it themselves. If you're a smaller company, maybe you can finance it yourself, or maybe you can talk to some of the patent brokers and others that can help with that, right? There's monetization companies can help with that. There's kind of patent backed loans that you can do for that sort of thing, right? And so there's different options to kind of get you going. And once you kind of have all that in place, I think the next thing you need to do is you got to continue to monitor your competitors. You got to understand where the market's going, and then kind of have your patents aligned with that, right? And ultimately, you need to pick the right target and begin your licensing campaign with that target. We can talk about this more, but you don't want to kind of start with the biggest target out there. You want to probably start with a smaller, more bite-sized target and go up from there, right? And you want to just be very process oriented about it, right? You want to draft your claim charts. You want to kind of test your arguments. You want to anticipate their responses and be fully prepared. I mean, the advantage you have on the offensive side of things is you can be fully prepared before you ever sit down with somebody about your patents, right? And so take the time to do that so you can put your best foot forward and make the strongest arguments as soon as you talk to somebody.
Ryan, anything to add to that from an outside counsel perspective?
Yeah, I think it's great. I think I would just add that, perhaps, maybe there's a line of patents that is no longer considered valuable that could be, packaged up, siloed off, and sold off to, a third party, which is a slightly different strategy, but I've seen it happen where a company decides to move in a different direction. Maybe they don't want to take on, the litigation aspects as picking a target and suing. Not to say that it's a better way to go. It's just kind of shedding patents that are no longer in line with the core business, or is taking too much resources. You could look at it as a way to recoup the value on that, and perhaps get more value if you're selling the patents along with, let's say, software or know-how that was used to create them. That could also be a way to generate value from IP in a deal structured type mentality.
Makes sense. Mark, Ryan just used the word silo, which I'm going to use in a different context here. So, which is that all of the items that you've been discussing, they're highly strategic and they're sophisticated. And that kind of work typically cannot happen solely in a legal silo, right? And so what is your secret or your approach to breaking down those internal barriers within a company and getting R&D and finance and corporate strategy to speak the same language around IP value?
Yeah, so I think it starts with communication, right? You just want to have regular meetings with these folks. Start with the executive team, make sure they know who you are and kind of what your strategy is, and use that to then leverage these meetings with the other folks you mentioned, like R&D and finance and corporate strategy. And the more you have these regular meetings, I would say like a monthly cadence makes a lot of sense with these different folks. And it sort of breaks down the barriers, it builds trust, and it enables everyone to kind of speak the same language, right? Because the finance people understand patents, maybe not at all, or if they do in a different context than maybe what you're trying to do with them, right? And so the more you talk, the more they kind of understand it and where you're coming from, right? And then you can really align the IP goals with your company goals, right? Because you understand where everyone's coming from. And then you can really take the concrete steps you need to do to do the monetization strategy, right? By identifying the right patents, understanding what those patents cover, who they cover, understanding the proposed targets, and then ultimately getting approval to move ahead with the strategy, right? And that takes a lot of work and a lot of time because, in the beginning, no one may have even thought about monetizing their patents, right? And so don't think this is going to be a 1 week sort of situation, right? It's going to take, months and maybe years to kind of get there. But by slowly building that trust and doing the communication, you can ultimately get there.
That's great. Ryan, when you're brought in as outside counsel, how do you help facilitate that internal communication, the alignment, and the trust that Mark just mentioned? What is your specific role in translating the legal team's IP insights into language that the rest of the leadership team can understand and act upon?
Yeah, absolutely. When I'm brought in, my core goal is always to make my in-house counterpart or colleague look great and try to bridge the gap with that communication to the C-suite and basically show value. I know that it's difficult to understand how a patent can translate into value to people that are outside of the IP space. So I think Mark is exactly right. You just need an ongoing education and setting goals as to, how the IP department will provide value on top of the IP that it's getting. Patenting a new portfolio can be expensive, but communicating that in both real value as well as the intangible values that can't be seen is important. One of the things that I like to do, for example, is it's possible to prepare like a presentation on blocking patents, which usually go unnoticed without more, but you can have a presentation to the C-suite that says, hey, look at these patents that we filed. It cost us X dollars, but we were able to block 80 patents from our competitors. Oh, by the way, 10 of these patents could have been directed toward, our core product lines, and they are not, they don't exist because we were able to block them. Take a look at this office action where the examiner, cited our art that, or, our prior art reference that we, filed a few years ago as a patent. This broad patent is not out there causing us problems. And because of that, our revenues are potentially increased or not affected. And so showing that kind of value where it's kind of hard to see it like on a line item in a financial statement is important. And so I think that communication that Mark mentioned in view of these, more delicate, touch points is a great way to do it.
Makes sense. For those companies who may not have the privilege of your expertise, what is the single biggest mistake that you think companies make when they first get, decide to get serious about unlocking the value of their IP? And that's to both of you.
I could start if you'd like. I think the biggest thing, we kind of hinted at this, but it's biting off more than you can chew, right? Like you don't want to jump into a monetization campaign by suing your largest competitor on like a couple of patents, right? Like that's not a great way to do it. Like it may work out. Chances are it probably won't work out, right? I think before you do that, you need to really understand the market. You need to understand all of your relevant patents, right? Like what do they cover? What don't they cover? And really do your due diligence, right? You got to kick the tires on these things. You've got to understand not only is the infringement rate potentially good, but the validity is good. And they're going to stand up to an IPR or some sort of patent office proceeding challenging the validity, right? So you're in the best position to take the time to do this before you approach anybody. And so have all your ducks in a row and then start your discussions probably with a smaller competitor, right? Kind of test the waters, make sure you can withstand their arguments and their validity challenges. And then you'll have a track record that you can then use for the next bigger competitor and kind of work your way up the food chain, right? And then you can point to the fact that, hey, others have licensed this, others have challenged this, and we've survived the challenges. We've maybe set, a reasonable royalty rate, right? And others have agreed to this rate, and so you should apply to this rate across the board, right, with all your other competitors, right? And so kind of taking those baby steps and making sure you're doing it in a methodical manner, I think is the best way to avoid big mistakes.
Ryan, any thoughts on that?
Yeah, Mark covered the litigation side pretty well. I'll speak to the prosecution side. I do prosecution for Fortune 500 and startup companies all day, every day. And I think some of the biggest mistakes is not having what Mark mentioned earlier, like a cadence as to when to meet with R&D teams to develop a patent portfolio. Some of the most successful companies that have patents or focus on their R&D are ones that continuously file patents on even incremental improvements so that everything is covered, and regardless of whatever direction that the market moves in, they can have a patent on that, and they can add into the patents those fringe areas maybe they're not practicing yet, but it's more in the white space that can provide like a blocking patent, or it could provide additional material for continuations. Some of the best patent portfolios or patents that I have seen are large patents that have a lot of disclosure in them that provide a wellspring of continuations that can be used to target competitor products specifically as they come out. You file one of these patents, keep it alive by filing continuations. And then as soon as a competitor announces a product, or as soon as that product comes out, you can analyze it, and you'd have enough support in your patent specification to draft claims directly on that product. Can be a very powerful way to do exactly what Mark talked about is, prepare your litigation claims and get ready for your strategy. With those types of specific targeted patents, you can control the market pretty well.
Makes sense. As you were sharing that, Ryan, I was thinking, you mentioned the filing continuations on an ongoing basis. And I think that really speaks to the mindset shift that needs to happen within the company that, it's not a cost every time you file that. It's actually adding business value because of all the benefits that both you and Mark mentioned. So that's an interesting insight. Mark, for the in-house counsel listening, what is one question that they should ask their business counterparts immediately as soon as they finish listening to this podcast to start this conversation?
Sure. So I think first it's got to be the right audience, right? So like I said, I like talking with the corporate development people, the finance people, because they're familiar with doing deals that advance the company's interest, right? And so it seems like the right audience. And before you have that conversation, you need to start by understanding your portfolio, right? Like what technologies does it cover? Are the patents, are they covering stuff that's detectable, right? Can I readily determine whether my competitors are doing this? Is my claim scope good, right? Does it not only cover my stuff, but does it cover my competitor stuff? And in what aspects does it cover it? And so once you have all that information, then you can go in and you can ask the question, hey, do you want to monetize IP to increase not only our revenue, but help fund the IP department, right? And so now we're maybe, self-funding, which would be great, right? I mean, that's the way the US Patent Office does it, right? They actually, their fees cover their expenses, right? And that's a great way to be if you're a department within a company, to try to set it up that way. So there's kind of an advantage for everybody. And then, just explain the high level options to your leadership, right? Like, what do we want to do here? Do we want to sell patents? We want to maybe take patents that we'd otherwise prune, like Ryan was saying. Maybe they're not strategic anymore. Maybe they're later in life and they cost a lot of money and we're not using them. Do we want to sell those instead of pruning those? Do we want to maybe license those? Do we want to license maybe something that's more core? Or do we want to, just license stuff around the edges that's more adjacent, right? What are we comfortable with, right? And then once you do that, really just explaining what to do next, right? Do we want to go out and license these things? Is that consistent with our strategy? Have we made the investments to be prepared for litigation if it comes to that, or be prepared for someone challenging our patents, and understanding all that strategy. So they understand the pros and the cons, right? Because you don't want to be, have the cons in your head, but never articulate those, right? Because that's the best way to kind of get in trouble, right? So make sure they understand the full story and they're comfortable with that. And then, once you're there, kind of get the buy-in and then, launch the program as we've kind of laid it out today.
Makes sense. Ryan, for the business leaders who are listening, what is the first question that they should ask their IP counsel to gauge if their IP function is truly ready for this shift with all the pros and cons and everything that Mark just mentioned?
Yeah, I think Mark covered it really well. Just as an outside counsel perspective, just know the company well, and if there is some type of strategic shift that's happening, like Mark said, with respect to the game plan that they're following, as an outside counsel, you want to know that so you can support better. Whether that be building a portfolio for future litigation, building a portfolio for currently anticipated litigation, or just building a robust portfolio for the company to have as defensive assets later on. I think that being aligned with that strategy is very important. I see a lot of patent attorneys just maybe not even knowing what the end product is or not fully understanding the client. And so I think it's vastly important that you understand the client's goals and their current IP strategy in order to provide effective support. So I like to read news articles about where the company is going, what they're doing, even taking a look at the 10K of the company and seeing what they say is their future outlook is very, very important. And then to align that with the IP strategies that we've mentioned on this call and that are also in our paper. I think that's very important to line it up, because then when you have those monthly check-ins, then you are on the same page. You are saying the right things with respect to how the company is viewing the world and wanting to move forward.
Sounds great.
And one thing I'd like to add to that, maybe
Please.
if I can, is just on the patent, sort of education side of this, right? When you're having these regular communications, one thing people maybe don't understand, like even if you sell a patent, it doesn't mean that we're giving up like protection of that patent, right? Because we're always going to insist on a license back that covers our products, right? And so I think people need to understand that we're not increasing our risk by potentially even selling a patent or licensing the patent. We're still going to ensure that our patent covers our product and that our product is protected. So just kind of getting that understanding, because a lot of people think you sell the patent, kind of getting rid of all of our rights. And that's not typically what people do. And so just having people understand that there is some risk in all of this, right? But we're trying to minimize those risks and do it in a way that really won't upset a lot and has enough upside to make it worthwhile doing.
That's great. Well, Mark, Ryan, this has been a great conversation. Final ask of you. Your teams were kind enough to share an advanced copy of the article with me. But for those who are listening, where can listeners find this article? And we'll add it in the show notes as well. But where can we go to find it?
I know it's publicly available on ACC docket. It's not behind a paywall, and people can freely access it and read it, which includes things that we've discussed on this podcast, as well as additional ideas. I think it's quite robust, and I had a pleasure writing it with Mark.
Yeah, and I'd just like to say it's also linked in both of our LinkedIns. And so if anyone wants to check out our LinkedIn, they can find it and find a link there also.
Excellent. Well, Mark, Ryan, this has been a great conversation. Certainly insightful for me in terms of the complexity and the sophistication behind the IP strategies that you've discussed in this paper. So thank you both so much for your time, and we'll see you on the next one.
Thank you.
All right, thanks.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.